have to ask me short again. I haven't got my notebook. I'll ask for it.
This is an appeal in the matter of Rafiu and Ahmad and the Laing department.
Can you start very slowly? Justice Lewis hasn't got his notebook.
No, my clerk's
So,
well, good morning, my lords and my lady. I can start with that. Would it help just to tell the court what bundles there should be while
yes.
my Lord or Justice
Why
Lewis
not?
doesn't have his notebook? So there should be an authorities bundle for both appeals.
Yes.
Which is 2 volumes.
Yes.
And then a core and a supplementary bundle in Rafiu.
Yes.
And the core and supplementary bundle in Ahmad. And perhaps I should introduce everybody as
Please.
well. So I appear with Mr. Yarrow for the Secretary of State in the Rafiu case. And
sorry, I've got just a mental blank. Is it Smith or Smythe?
it's Smythe.
Smythe, thank you.
And then I appear with Mr. Yarrow, and then Mr. Pobjoy Casey is the advocate of the court in
Yes.
Rafiu.
Yes.
And then in the Ahmad case, Dr. Shah appears for the appellant and Mr. Yarrow appears for the Secretary of State.
Yes.
So we did have a plan and just wanted to check that the court thinks it's a good plan for the hearing.
Yes.
So the plan was obviously I start
Yes.
the Rafiu case.
Yes.
And then Mr. Pobjoy addresses the court
Yes.
in reply. And then
Yes.
we wondered whether it might be simpler for the the Ahmad appeal to go next.
Yes.
And then if I reply all at once on ground A type issues at the end after Mr. Shah, has spoken, and Mr. Yarrow responds in that case, and then Dr. Shah has a right of response at the end, and that saves the court hearing.
So
twice
it's
on-
you, Mr. Pobjoy, Dr. Shah, Mr. Yarrow. Is that the order you were thinking?
Yes,
Then
me on ground A.
yeah, and then replies as may be appropriate, and we can deal with that when we get to it.
Yes.
See whether people think they've new points been raised or whatever.
Exactly.
Okay. Yes.
I
Thank
didn't
you.
do a good job of explaining that. Let's hope I do better with the rest of it. So broadly, I'm proposing to adopt the following structure. I'll just deal with the legal framework, and then I'm proposing to make submissions on ground A, which is the construction issue, and then finally I'll deal with the facts and grounds 1 and 2. And does the court want me to deal briefly with where we are in terms of permission and so on, or the grounds of appeal as now amended, and in respect of which my Lord Justice Lewis gave us permission, are on page 15 of the core bundle.
Yes.
And can I acknowledge at the outset the wholly unsatisfactory way in which ground A has reached this court? That is addressed in detail in our written argument. We apologise unreservedly for that. I wasn't proposing to address that further unless it would assist the court.
No, there's no indication, I don't think, in the papers as to the extent to which this is an issue that arises in other cases.
Yes, and your lordship may recall we debated that to some extent
did we?
at the interim hearing.
Yes.
So we have referenced in our skeleton some unreported decisions and
You
one
have?
reported one.
Yes.
I'm not aware of any other pending cases, but I'll ask those instructing me to confirm that there is a concern that the issue be resolved, but I will check on extant appeals and so on.
But there can't be any new cases because on any analysis, this problem came to an end if somebody hadn't made an application by the 30th of December
Yes.
2020. It is now truly historic.
Yes. So it certainly, yes, it would have taken a very slow decision and a very slow appeal. Yes, your lordship's right. We're not aware of any.
Okay.
Same answer as October.
Right, thank you.
So with that then, can I turn to the first part of my submission, which is to deal with the law? and I'm going to deal with this in three broad parts, and I'll be chronological as far as I can. So first, I just wanted to deal briefly with the Zambrano right when EU law applied, because we say that's important context, and it's also relevant to grounds 1 and 2. Second, then I wanted to deal with the ending of free movement rights in the UK and the consequences specifically for the Zambrano right. And then thirdly, to deal with secondary legislation, and in particular what we have called the grace period, SI. And I'll explain that when we get there. And I'll deal with what we have called the consequentials SI, which is the key instrument at issue in this appeal when I'm making submissions under ground A. So with that then, could I just invite the court to open the first authorities bundle and to turn up, and we won't need to spend long here, but could I ask the court to turn up, it's tab 26, authorities page 531, it's Zambrano itself. And I just wanted to invite the court to read paragraphs 40 to 42, which are on page 584.
42, 42.
40,
Yes.
42 on
Okay.
page 584.
Yes.
So 2 points to draw from that. The first is that the right stems from Article 20 of the treaty, which is the provision on citizenship. And second, it is an exceptional right. This was a groundbreaking decision when it came out. The reason being that it's a right that can be asserted by somebody who's never exercised the right of residence. So, in effect, it's a right of a citizen residing in their own member state of nationality, and it's a right to say to their own member state, I'm entitled to keep my union citizenship rights, and you cannot remove my primary carer if that would result in me leaving the EU and so losing all of my rights. So that's Zambrano.
And that's the facts of Zambrano as well. It so happened that they were all in the member state. There was no question of the court having to rule on whether or not a child who didn't happen to be there but could return could be accompanied by a parent. It just doesn't deal with that, does it?
It doesn't, no. There are some cases, and I'll show the court the two key ones dealing with families and the circumstances in which a family unit might or might not be able to benefit from a Zambrano right. So the second CJAU decision to show the court is Chavez-Vilches, which is at tab 25 of the bundle. Now, the facts, because this concerned, I think it was something like 8 cases. There were lots of different facts, so I won't show the court all of the facts, but just beginning with the judgment on page 514. Paragraph 2, there were 8 cases before the court.
Yes.
And then if the court looks at paragraph 11 of the judgment on page 517, that's the national provision that was at the core of this case. And what that said at letter E.
Wait a minute. Paragraph 11.
Paragraph 11 on page 517 of the judgment.
Yes.
What that said at E is
Yes.
that the IND, which was the national authority,
Yes.
shall in any event not assume that the child, whose father or mother is a foreign national, is obliged to follow and leave the territory of the EU if the child has another parent who's lawfully resident and that parent is in fact able to care for the child. And then, and this was the particularly troublesome bit, it said the IND shall in any event assume that the other parent is in fact able to care for the child if the other parent has custody of the child or is still able to obtain custody, and the other parent can make use of help and support services related to the care and education of the child offered by public authorities. So what the Netherlands authorities were doing was basically saying this right can only apply in very limited circumstances, and if there's another parent on the scene, then unless there are quite some serious circumstances affecting that parent, you're not going to get the Zambrano right. So that was the national provision. And then, just for the court's note, there are 8 cases, and those are described at paragraphs 20 to 29, and there were varying degrees of involvement of the fathers in those cases. So could I then ask the court to turn up paragraph 62 of the judgment? Again, just some important features of the Zambrano right captured in this case.
Did any of these cases involve a child who was not in the Netherlands?
No.
So it's all again about children in the Netherlands?
Yes.
Right.
Yes, we will just double check that. That's my recollection from looking at the facts, because certainly I checked and all the parents were in the Netherlands.
Yeah. So you assume the children are, yeah.
Yes.
So 62, yeah.
62. So what that says, Proposition 1, the treaty provisions on citizenship of the Union do not confer any autonomous right on third country nationals. They're derived from those enjoyed by an EU citizen. So it's restating the orthodoxy that the Zambrano right is not an independent right of the third country national who is seeking to claim it. And then paragraph 65 captures the relevant test. So could I just ask the court to read paragraph 65?
Yes.
So there, the language of the child being compelled to accompany their mothers and therefore to leave the EU as a whole, the mothers being obliged to leave the territory of the EU. So there are, for the court's note, repeated references to the compulsion test in Chavez-Vilches, and the word compulsion and obliged are used repeatedly. To give a couple of examples, paragraph 63, there is a reference to the EU citizen being obliged in practice to leave the territory of the EU. Paragraph 69, again the same language is used, the dependency leading to the EU citizen being obliged in practice to leave the EU. Paragraph 70, in order to assess the risk that a particular child who is a Union citizen might be compelled to leave the territory of the EU and thereby be deprived of the genuine enjoyment of the substance of the rights. And then finally, again at paragraph 71, there is a reference there to the child being compelled to leave the territory of the EU. So what is clear from Chavez-Vilches, and indeed from cases that have followed, is that for the Zambrano right to be engaged, there has to be a situation of compulsion, and it has to be a situation where the child would in practice be compelled to leave the EU. And I'll show the court two cases in this court, one in the Supreme Court, one in this court, which illustrate the point in terms of a family unit. And all the children in the Netherlands as well.
Right.
Yes?
So that's the test. The other important part of this case, so far as the Rafiu case is concerned, is about dealing with proof, because what the court goes on to say is the applicant has to prove that they benefit from the right. So could I invite the court just to read paragraphs 74 and 75 on page 528?
'74 and '75.
74 and 75.
Yes.
So in 74, it's for the applicant to demonstrate, just by F, that because of objective impediments that prevent the EU citizen parent from actually caring for the child is dependent on the third country national parent to such an extent that the consequence of refusing to grant that third country national right of residence would be that the child would be obliged in practice to leave the territory of the EU. So that is in the context of these cases, which are all about single parents with fathers who were either not involved at all or involved to some extent. So, and second, in paragraph 75, it's for that third country national to provide evidence on the basis of which it can be assessed whether the conditions governing the application of that article are satisfied. In particular, evidence that a decision to refuse a right of residence to the third country national would deprive the child of the genuine enjoyment of the substance of the right. So the applicant has to engage with this. They have to provide evidence. It's not for them to say, well, we're a family unit, so give us the right, please. They've actually got to engage with the test. What the court goes on to say in paragraphs 76 and 77 is that there's still a role for the national authorities. So what the national authorities need to do, and this is at 76B, is ensure that the application of national legislation on the burden of proof doesn't undermine the effectiveness of Article 20. So it doesn't, at paragraph 77, relieve the authorities of their obligation to undertake, on the basis of the evidence provided, the necessary inquiries to determine whether the parent who's a national of that member state, and so on. Because
well, that's challenging the assumptions, isn't it?
Yes.
They're contained in the local legislation.
Precisely.
You have to come to the facts from an objective point of view.
Yes, exactly. So you can't just say, oh, well, he's not dead, which I think was one of the cases, therefore he can care for the child. And the national authorities may have its own information, for example, but the applicant's got to provide the evidence in the first place. And to be clear, we say that is relevant in relation to one of the points the applicant has taken, which is, well, they didn't know what the Secretary of State's case was. The answer to that is the decision letters were clearly not good in this case. However, the primary obligation is for the applicant to turn up with their evidence, present it to the Secretary of State and say, for example, if my husband doesn't come with me, I'm not coming. And
I thought the problem in Mrs. Ahmed's case was that the entry clearance officer and the first tier tribunal simply never considered a claim based on primary carer. They only considered the dependent Irish son.
I can't speak to that case, but I'll let Mr. Yarrow answer. If your lordship would like an answer now.
Then don't worry, no.
No, no.
Mr. Yarrow will make a note and will tell me why I'm wrong later.
Yes.
Yes, my lord.
Yes. So that's Chavez-Vilches, and then 3 domestic conditions, starting with Patel, which is a Supreme Court decision at tab 28 of the bundle. So just from the head notes at the top of page 596, there were two cases before the court in Patel. One was a case of a third country national who cared for his father, who was an adult, and that was the Patel case. And then the Shah case was a family unit type case where the father, who was a third country national, was seeking to establish that he was eligible for a Zambrano right, and the Secretary of State had won on both in the Court of Appeal, but in the Supreme Court only won in the Patel case. So paragraph 22 again is, and that's 606 captures the principle, the Zambrano principle. It's sidelined.
This again, the relevant parent and British national child were in the United Kingdom.
Yes.
It's not an entry, it's a leaving case. Yes.
So there, in relation to entry, there was a decision of the Upper Tribunal back in 2013 which says the Zambrano principle applies in a coming to the UK case.
Right, okay.
And the Secretary of State, as I understand it, has accepted that.
It's accepted it.
Yes. 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 So paragraph 22, it's the role of the National Court to determine, and here's the key language, whether the removal of TCN carer would actually cause the union citizen to leave the union. So it's actually caused.
Well, we've got all the obliged.
Yes.
You know, I mean,
Well,
are we getting really into actually caused rather than obliged, or
well,
you know, in practice obliged? I mean, does it help?
It is important in the sense that actually caused rather than hypothetical, and that can I just show?
But it's in practice, and
in
this,
practice,
this
yes.
I mean, I appreciate this is a domestic court, but this is the domestic court interpreting the CJEU cases.
Yes. Can I just show?
And we're actually interpreting domestic legislation in this case.
Yes, although the background is relevant in terms of if I lose on Regulation 16.
Yeah, okay.
So paragraph 27 is rejecting the case in relation to the adult carer. I just note that, I don't need to ask the court to read it. But
Thank
paragraph 28, out of fairness in this case,
28.
paragraph 28 is why the Secretary of State lost in the Shah case.
Thank you. Right, so that's just saying that the trial court, so to speak, the FTT, had found facts,
Yes.
and there was no justification for any upper court interfering with those facts.
Yes, relevant to ground 2, in Rafiu. I won't need to make a lot of submissions about ground 2. I'm in effect doing that now. So two key findings of the first tier tribunal in this case. First, the finding of fact that he is the primary carer and has by far the greater role in his son's life. And then importantly, and this is crucial, the mother's evidence that if Mr. Shah wasn't allowed to stay in this country, they would move as a family. And it's that evidence that means that the child will in practice be forced to leave the EU.
Yes.
So contrast then the case of Velaj, which is in the authorities bundle at tab 36. That's this court, and that is construction of the domestic legislation as opposed to the EU law.
This is a question of fact, and you lost in the Upper Tribunal on the facts.
Well, I'll deal with that. That's when I get to ground 2. But yes, I think the difficulty was there wasn't any evidence to support the conclusion that was reached, in the sense that the Upper Tribunal assumed because they were a family that means there wasn't actually a finding. But perhaps when I show Your Lordship the Upper Tribunal decision, it will be a short point, and the court's either with me or not, I suspect.
Right.
So in Velaj, the issue is captured at paragraph 13.
Yes.
So the issue is whether a person deciding whether the requirements of Regulation 16.5c are fulfilled must consider whether the British citizen dependent would be unable to reside in the UK on the assumption that the primary carer or both would leave, or whether the decision maker must consider what the impact would be if in fact the primary carer would leave. Now, just to contrast this case with the factual situation in Patel, the evidence is at paragraph 18, and the evidence in this case was that Mrs. Velaj said she wouldn't go to Kosovo with her husband if he were deported, as she couldn't leave his mother and the children in the UK. Nevertheless, the appeal succeeded. So that was paragraph 18.
Sorry, say that again.
Paragraph 18.
Yes.
Her evidence, this is to distinguish from the Patel type situation.
Oh, I see what you mean. Yes.
And that, in answer to my Lord Justice Lewis' question, is that there is no evidence either way in front of the Upper Tribunal in the Rafiu case.
And the
It's not
tribunal
addressed.
wasn't entitled to infer that, having married her and lived with her and so on, that she wouldn't come to England without her husband.
Well,
his children.
2 points on that. One, the thrust of the case law is that it's not so much a case for inference as a matter for evidence and asking whether in fact the child would leave the EU. Second, had that inference been drawn, it would not have reflected what has actually occurred.
Yeah, well, you can't win on what happened afterwards.
Yes, but
when you said to the mother, you've got a choice there, you leave your husband and look after your child, or you look after your child in Nigeria. That's a different kettle of fish. You created that problem.
yes. But all the same, it is a question of fact which has to be decided. So that was paragraph 18, and the argument again was not that would give rise to a right under the EU jurisprudence. It was accepted that it wouldn't, but rather whether the domestic legislation was more generous. That's at paragraph 35 to 36. And then the court's answer to that question is at paragraphs 47, 49 in particular. So perhaps I could just invite the court to read those passages.
Yes.
So that, I hope, addresses my Lord Justice Moylan's question about what about the domestic legislation. That's what this court had to say about it. The other decision of this court is Akin-Sanya, which is at tab 37. I needn't take up time with that now. Essentially, that case had a complicated background. It was about whether, when making the rules in the EU settlement scheme, the Secretary of State had misunderstood her own legislation. Akin-Sanya is considered in Velaj. The core point in Akin-Sanya, and for the court's note, the core conclusion is at 55, is that as a matter of EU law, a person who has got some other domestic right of residence does not benefit from the Zambrano right. But I don't think I need to take up time with that now.
Yes.
So the other important feature before I come to how the rights worked under the 2016 regulations is just to say that under EU law, residence documentation is declaratory only. We didn't include in the bundle because we didn't understand this to be controversial. Two cases that decide that, they are Diaz and Petraea. But if the court would like, we can hand up a copy of Diaz. But effectively, the parties have agreed that under EU law, if you have a piece of paper saying that you enjoy a...
It's not the paper that gives you the right, it's the paper that demonstrates that you have the right.
Yes, exactly.
So, I mean,
so
yeah.
either if you have the piece of paper but you don't have the right, then the piece of paper doesn't help. That's the point.
Well, okay. So you shouldn't have been given it in the first place. Is that what you're saying?
Well,
They're not
might
sure. I
have
mean,
been-
that's
you
a different.
You might have been given it because you enjoyed the right at the time, but once you stop enjoying the right, a piece of paper doesn't help you. That's the Diaz case.
Right.
You might have been given a piece of paper wrongly. We've had
Okay.
discussions about that in another case, in a different context. But so far as the Zambrano right is concerned, you don't need a piece of paper to be enjoying the right in law. And if you have a piece of paper saying you've got the right, that doesn't mean that you have it. So that there's no dispute between the parties on that point. But as I say, if it's helpful, we can hand up DS.
No, it's all right.
My
The
fault.
way you just, it sounds almost like catch-22.
Well, it's not.
You-
It's
No, don't worry. I
It's-
just, the way it,
it's-
you do but you don't, or you don't but you do.
Well,
I mean, yeah,
It's,
okay.
what it is as a matter of EU law, it all matters. The substance matters, not the piece of paper.
Yes.
So, if you haven't got a piece of paper, you're not disadvantaged. But equally, if you have got the piece of paper, you still need to be satisfying the conditions of the right. The only situation where that's different is what's known as the extended family member right, where the piece of paper actually gives you the right. But that's the only situation. So, and I think every member of this court has heard quite a lot about that in other cases. But we say the fact that it's declaratory is important context for the statutory construction exercise, and I'll explain why when we get there. So looking then at how the Zambrano right worked under the 2016 regulations, those are in tab 8 of the authorities bundle at page 44. Now we did take the liberty of handing up a fuller copy of the 2016 regulations just in case any questions came up about what other bits and pieces I said. I think my Lord or Justice come prepared.
Right.
But for now, we don't need to turn
Okay.
up
Thank you.
that. The authorities bundle, regulation 16 is at tab 8. Sorry, the 2016 regulations are at tab 8. Regulation 16 is where I need the court to look first, and that's at page 56.
Well, but don't you actually need to look at 11 and 12 and then 15 and 20? Because you've got two state of affairs. You've got the right of admission. Can I pass through the gates at Heathrow? And then there's how long can I stay afterwards?
I'm happy to take it in that way. I was going to take regulation 16 because we say that's the meat, and regulation 11 is about getting in if you've got the meat, basically. So I can take regulation 11 first. So regulation 11 is the right of admission to the UK, and this means exactly as my Lord Justice Lewis says, can you get through the gate? You can get through the gate if you enjoy a right of residence. So regulation 11.1 and 2 on page 51 deal with the situation of family members. So regulation 11.1 is the EEA national themselves. They must be admitted. This is one EU law applied to the UK. If the EE national produces a valid national identity card or passport, that's straightforward. French citizen coming here to work, for example, or just to visit. And a person who is not an EEA national, this is 11.2, must be admitted to the UK if that person is a family member of an EEA national and produces on arrival, etc., etc., or they are one of the people in category 11.2b. So, for example, a family member who's retained the right of residence, that's a particular class of person who enjoys a right after divorce.
Yes.
So that's 11.1 and 2. I'm putting my finger on 11.4, but I'm going to come back to it because it makes sense to look at regulation 11.5 first. So regulation 11.5 is dealing with derivative rights holders. So, sorry, I should have started at 4. Authorities 51.4 is about the circumstances in which an immigration officer has to let somebody in. In other words, if they turn up without a document, there's still got to be a substantive examination of their circumstances. So 11.4, before an immigration officer refuses admission to the UK to a person under this regulation because the person doesn't produce on arrival or the time of his production of the required documents in a control zone or supplementary control zone. So he doesn't produce on arrival a document mentioned in paragraph 1 or 2. So an EEA family permit, a residence card, a derivative residence card, a permanent residence card. The immigration officer must provide every reasonable opportunity for the document to be obtained by or brought to the person, or, and this is significant, or allow the person to prove by other means that the person is an EEA national, a family member of an EEA national, or a person who meets the criteria in paragraph 5. So somebody who enjoys a Zambrano right to reside can turn up, or can't anymore, could turn up at the border and say, well, I haven't got a piece of paper, but listen to my story, here's my evidence, I meet the criteria. What are the criteria? They are set out in 11.5, and they are...
But if they had the permit, they wouldn't even have to sit and listen to the story.
Yes.
They'd hold the permit up, and the immigration officer would tell me a bit more, and she'd say, no, you've had enough now, and he'd have to let her in with the permit. The document is of itself the answer to, am I allowed to enter?
Well...
if she's got it.
Yes, but recall that the document, it's not entry clearance.
No.
It's not entry clearance as in the Rexhaj case. It's effectively a declaratory document. So
it's a document which says the person has got a family permit and can come in, and the person can't be stopped from coming in.
Well, they can if the immigration officer were to ask them questions and it were to transpire that they didn't in fact enjoy the right, and that's Diaz. That's the point of the document being declaratory.
So before we left the United Kingdom, somebody came to the United Kingdom with a permit. They come in, but you're saying things have changed after, even though they've applied beforehand. They haven't come in before the end of the transitional period, and you're saying at that stage, even though they've got the permit that they should have had some time ago, they can be stopped coming in.
Supposing somebody turned up with their EEA family permit on the 1st of December and they said to the immigration officer, well, I don't actually have a British citizen child. I haven't got a British citizen child. The immigration officer would say, well, that piece of paper is declaratory. You don't actually enjoy the right. Now, I accept that's quite an extreme situation, but it is important to the analysis that the right is, the piece of paper is declaratory. So in practice, it may well be that the immigration officer doesn't ask, but it's not entry clearance. So contrast entry clearance, where that takes effect as leave to enter at the border, that's the end of it. It's a piece of paper recording that on a particular date it was accepted that you had a right of residence under Zambrano.
And it has the consequence the person has to be admitted.
Suppose, for example, that on the day they applied, it's a horrible example, but suppose on the day they applied they had a British citizen child and all the requirements were met, and by the time that they arrive the child has something that's happened to the child. The fact that they had the piece of paper wouldn't mean they could enter.
It would. They couldn't be refused admission if they produced them. If you asked further questions and so on, it's interesting what would happen, but if they stood in front of the officer with the piece of paper and refused to say anything more, they could enter.
My lord,
they'd have to be allowed to be admitted.
So the answer to that is no, and there are powers to revoke documents. But it's, I mean, for example, if you take, and perhaps I should hand up the Diaz authority, the fact that Miss Diaz had a piece of paper saying that she had a right of residence did not mean that she had a right of residence. So
no, I understand that. I'm not saying that. What I'm saying is the only requirement in Rule 11, and we don't have to take time on it,
no.
All it says is that you must be admitted if you've got an EEA family permit. So if she's got an EEA family permit, the starting point is she's entitled to be admitted.
The starting point. I'll accept the starting point, yes. But I also make the point, and we say it's an important one, that it is not entry clearance. So it's a recognition of enjoyment of a particular right as at the date of application. And that, yes, so I'll show the court in a moment 12.2b,
Yeah.
which talks about that you would enjoy the right. You will meet the criteria for admission. That's what it's saying. But if in fact on the date that you arrive you don't, the piece of paper, unlike leave to enter, will not have the result that you should be admitted. Now the difference in the Hassanaj and Vaza case is that they were extended family members, and
But they were under United Kingdom law.
Exactly,
They had to
yes.
have a decision creating a right, and that was given by
Yes.
the decision of the immigration
Yes.
officer.
Now-
This is different, but
Yes,
this is
and-
a formal thing. If you've got the piece of paper, you can come in.
yes, I mean, the flip side of the coin, of course, in these cases, is that the Secretary of State said you can't have the piece of paper.
No, she didn't.
What?
She never considered it. Oh, when in Rafiu.
In Rafiu,
She
yes.
did, yes.
So, because the right has gone. So, in that sense, I mean, I can't deal with the other case, but
Yeah.
in Rafiu, that it's the opposite of Hassanaj and Vaza, quite apart from the extended family member point. The Secretary of State saying, or should have said, well, hold on, you've put in an application on the 18th of December. You're saying you want to come to the UK on the 29th of January 2021. The straightforward answer to that application is we're not giving you the piece of paper.
Yeah.
It's because
But the
it's
answer
a
is-
right that doesn't exist.
We've got to look at the regulations, and the starting point, the regulations you've showed us so far simply show that if somebody has the relevant family permit, they can't be refused admission. That's the starting point. And then we have to see what happens when you've applied before and it's continued after.
Yes. So, my junior has just reminded me that 11.2b, it's not simply presenting the document; it's meeting the criteria and producing on arrival. That's a family member of an EEA national.
Yeah.
And the same for a person who meets the criteria in paragraph 5. So
Yeah.
they have to meet the criteria and they have to produce the document. And that,
Where does 5 say about the document?
Little 2B2,
2b2.
valid family permit.
2B. Hmm? 2. Okay.
So you can either get the document, but you've still got to meet the criteria, or you can just take the chances and turn up at the border. So somebody could have turned up on the 29th of December 2020 and said, I've got Zambrano right and here's my proof, without any piece of paper. Equally, if they turned up with the piece of paper, they still needed to meet the conditions, but it obviously smooths their path. So the criteria, a person who meets the criteria in paragraph 5, they're set out at authorities 52, regulation 11.5. So this covers paragraphs 5A, B, C and D cover Ibrahim, what are known as Ibrahim and Teshira carers and Chen carers. So I don't need to take the court to those provisions, but Ibrahim and Teshira is a child who enjoys a right to education because their parent has been a worker. Their primary carer gets a right to reside. A Chen case is the primary carer of a self-sufficient child. So a French child who has their own money comes to the UK, their parent has a right of residence. Now, there is a gap in these regulations so far as, if I can call them, sibling cases of Zambrano are concerned, because what the court will see is that at 5D, the criteria in this paragraph are that a person is accompanying a person who meets the criteria in subparagraph B or C, the relevant person in the UK, and P and the relevant person are both seeking admission to the UK for the first time, or returning to the UK, having previously resided there pursuant to the same provisions of Regulation 16. What this does is capture other siblings, in effect, but that provision is missing for Zambrano cases in Regulation 11.5E. that is a drafting error, because certainly the Secretary of State has accepted that EEA family permits can be granted to Zambrano siblings. And that we'll see that the same gap in Regulation 12.
Yep.
So then going to Regulation 12, which is about the issue of EEA...
Well, you need to look at 1151E.
Yes, sorry, I skipped over it, but
Yeah.
that's the Zambrano provision. So it is accompanying a British citizen to or joining a British citizen in the UK. And P would be entitled to reside in the UK under Regulation 16.5, were P and the British citizen both in the UK. So that doesn't deal with the position of siblings, but it does capture the Zambrano right.
Yes,
to
it does
care.
mean that somebody coming from Nigeria or Pakistan who had a British national child would be entitled under the British regulations before we left to come into the United Kingdom. Even though they weren't resident here, the child would be entitled to be resident, and therefore the parent is entitled to be resident.
Yes, and that's the way it's been interpreted.
Yeah.
So Regulation 12 deals with various categories of situations where an EEA family permit can be issued, and as I've said, this is not unlike other use family permit cases. It's not entry clearance. So Regulation 12.1 is about being a family member of an EEA national, and then Regulation 12.2 is dealing with derivative rights holders. So just a few features to note in Regulation 12.2. In order to get an EEA family permit, there has to be an application. So an entry clearance officer must issue an EEA family permit to a person who applies and provides evidence demonstrating that at the time at which the person first intends to use the EEA family permit, the person A would be entitled to be admitted to the UK because that person would meet the criteria in Regulation 11.5, and B will, and I'll just leave the bit out in brackets for now because it's about Ibrahim and Tashira cases, will be accompanying to or joining in the UK any person from whom the right to be admitted to the UK under the criteria in Regulation 11.5 is derived. So there's a need to apply and provide evidence that's reflective of Chavez-Vilches. We've looked at the criteria in Regulation 11.5, and again, there is no addressing of siblings here. That is an error. EEA family permits were issued to siblings. So then, looking on to Regulation 16, and this deals with the three categories of derivative right that I've already described. So 16.1, derivative right to reside during any period in which the person is not an exempt person and satisfies each of the criteria in one or more of paragraphs 2 to 6. 2 is Chen, 3 and 4 are Ibrahim and Tashira, and then 5 is Zambrano. So 16.5, the criteria are that the person is a primary carer of a British citizen. The British citizen is residing in the UK, although as my Lord Justice Lewis has pointed out, they may not be. BC would be unable to reside in the UK or in another EEA state if the person left the UK for an indefinite period. So it's not enough just to be a primary carer. You've got to satisfy that third limb, and that's the C limb, which is dealt with in Bellage. And then 16.6 covers what I'm calling sibling cases. So the criteria in this paragraph are that A, the person is under the age of 18, B, the person doesn't have leave to enter or remain under the 1971 Act, with an exception specifically dealing with use leave now. C, the person's primary carer is entitled to a derivative right to reside in the UK under paragraphs 2, 4 or 5, and the primary carer will be prevented from residing in the UK if the person left. So that's siblings. In other words, the parent would say, well, I can't leave my other child behind. And then 16.7, not relevant here, deals with exempt person. 16.8 is the definition of primary carer, and under the regulations that requires, and this is relevant to Rafiu ground 1, the person is the primary carer of another person if A, the person is a direct relative or a legal guardian, and either one person has primary responsibility or shares equally the responsibility for care. So that's a hurdle that needs to be crossed, but getting across it doesn't mean that you satisfy, because you've still got to meet 16.5c. I should just say while we're here, direct relative or legal guardian is not defined.
Yeah.
So Regulation 16 is in effect reflecting the Article 20 treaty right that we've looked at. The only other bits I was proposing to show the court in the 2016 regulations is Regulation 21, although Mr Yarrow...
Well, shouldn't we actually look at 20 as well? Because you
Yes.
have admission and then you have a residence card.
Yes, so that would be in the bigger...
Oh, yeah.
So, I'm so sorry, Westlaw does not have pages on its, and we didn't paginate it, I can't blame Westlaw, that's my fault. So, but Regulation 20, so derivative residence cards are for people in the UK. So, Regulation 21, the Secretary of State must issue a person with a derivative residence card on application and on production of a valid national identity card or a valid passport and proof that the applicant has a derivative right to reside under Regulation 16. And then the person gets a certificate of application under Regulation 22 and Regulation 25. It's proof of the holder's derivative right to reside on the day of issue. It's no longer valid if the holder ceases to have a derivative right to reside under Regulation 16. So that's the way of catching what's done under the admission provision by saying you need to meet the conditions. Here, it's no longer valid if you cease to have a derivative right to reside under Regulation 16. That reflects the derivative right point, and it's invalid if you never had a derivative right to reside under Regulation 16. Now, as we'll see, these could continue to be issued after the end of the transition period to Zambrano carers who were lawfully resident in the UK at the end of the transition period, and I'll show the court that in the...
Hold on, could be issued to Zambrano right holders.
Yes, so if a...
Hold on, could be issued to Zambrano right holders who were resident in the UK
lawfully at the end of the transition period. Because of what I've called the grace period SI, and just to highlight the point now, but I'll show the court, the grace period SI makes special provision for people who are lawfully resident in the UK at the end of the transition period, and for that cohort it specifically and expressly continues Regulation 16 in effect. So I'll show that if you're already here as a Zambrano carer, under domestic legislation, you could continue residing as such after the end of the transition period for a short period of time. What you couldn't do is establish a new right after the end of the transition.
Was the grace period 6 months?
It was, but those regulations then cover, at the end of the 6 month period, they cover somebody while their application is being decided as well. So supposing somebody makes their application on the 29th of June under the EU settlement scheme, they will then benefit from the grace period SI while their application is being determined and throughout any appeal as well.
And the person who applies on the 29th of December, so they're not into the grace period regulations, and they make an application before, and the Home Office amazingly takes 7 months. What happens to the person who applies before the end of the...
It depends. if they've applied, and perhaps it's easier if I show the court the consequential SI, the grace period SI. But if you fall within the grace period SI, and you're lawfully resident at the end of the transition period, and you might, for example, you might want to have something in February to show that you enjoy a status, and you might have applied in December 2020. That application can still be considered and indeed granted, because the grace period SI people are in a special position because they were lawfully resident at the end of the transition period. They go on enjoying the substantive right of residence.
The people that I'm concerned with when we get to the regulations are people who've applied before the end of the transition period. So they aren't preserved, unless you show us differently, by the grace period regulations, because that appears to people who applied during the grace period and or those whose applications haven't been determined during the grace period.
Not quite. So what it does two separate things. It preserves rights of residence under the 2016 regulations, the grace period SI, and the application that it allows a grace period for is the EU settlement scheme application. But at the same time, there's a continuation of the old documentation to some extent. So to take a simple example, two simple examples, if ever anything simple in this context, somebody before the end of the transition period might have applied for an EEA family permit. They would be under the consequential SI. Somebody else might have had a right of permanent residence as at December 2020, and they might for some reason have applied for a permanent residence card before the end of December 2020. The reason that they're in the grace period SI is not... It's because they were residing lawfully at the end of the transition period rather than because they've made an application.
You'll have to do it by reference to the regulations, but the question to address when you come to the regulations is this. If a person is resident in the United Kingdom lawfully before the end of the transition period and makes an application for a derivative residence card before the end of December, is their position affected by the grace period regulations? Because if not, we will then have to work out the meaning of the consequential regulations for regulation 20 residence card periods. And if we are doing that, that may shed some light on the regulation 12 period.
Yes, the short answer is yes, they are entitled to be granted a derivative residence card in that situation. It's a combination of the grace period SI and the consequentials SI.
Well, you show us the grace period regulations when we get there. Yeah.
Yes, of course. So regulation 21, then, back to the bundle, authorities 59. So Mr. Yarrow will be dealing with this in more detail in the Ahmad case, but just to highlight 2 points. Regulation 21.2, all applications must be accompanied by the evidence or proof required by this part and must be complete. And then regulation 21.4, where an application is submitted otherwise than in accordance with the requirements in this regulation, it's invalid and must be rejected. And then finally, regulation 36.
Well, then we have 6 as well. Circumstances beyond
Yes, that's
control.
right. Yes, Mr. Yarrow will be dealing with this in more detail, but yes, your lordship's quite right. Regulation 21.6.
Yes.
And then regulation 36.5. Regulation 36 is the appeal provision, page 61. The subject of an EEA decision may appeal against that decision under these regulations. And then regulation 16.5, if a person P claims to have a derivative right to reside, P may not appeal under these regulations unless P produces a valid national identity card or a valid passport, and then B4, proof that P is a direct relative or legal guardian of a British citizen. So the point should have but was not taken, and we're obviously not taking it now, that Mr. Rafiu had not produced proof that he was a direct relative or legal guardian of a British citizen.
Sorry, I missed that regulation. I'm so sorry. Which?
It's regulation 36.5 B4.
And that point wasn't taken?
No, it wasn't.
And are you taking it
No,
now?
I'm not taking
You're
it.
not taking it, so
No.
we don't need to interpret that, right?
No.
I thought from the skeleton you were...
We made the point that the advocate made the point, well, he didn't know he had to prove that he was a direct relative or legal guardian, and we said, well, the regulations said that he did need to do it. That's all. So that was all I was proposing to say about the Zambrano right and EU law and the 2016 regulations. I was just going to deal now with the ending of free movement rights and the consequences for the Zambrano right. So the ending of EU law in the UK and the withdrawal agreement, this is addressed, I don't need to invite the court to turn it up, in my Lord Justice Lewis's judgment in Chellick, which happens to be at tab 35, paragraph 7 and 8, just give the references. So the position is this, that until the UK leaves the EU on the 31st of January 2020, EU law has direct effect via the European Communities Act. And then the UK exits on the 31st of January 2020, and then there is a transition period during which EU law continues to apply, and that is given effect by Section 1A of the European Union Withdrawal Act 2020. During that transition period, Article 20 continues to have effect, and that follows from Part 4 of the withdrawal agreement. It isn't in the bundle. The reference is given at footnote 7 of our reply skeleton. But if it would be useful, we can hand up part 4 of the withdrawal agreement. But I think it's common ground that during the transition period, Article 20 continued to apply. What then happens, of course, from the end of the transition period, EU law ceases to apply. And under domestic legislation, there are two discrete sources of law that are left over in effect from the UK's membership of the EU. And so those two sources are first retained EU law, which is now called assimilated law. And that effectively brought various bits of EU law and so on into domestic law as domestic law. It's not relevant here for reasons I'll explain shortly. That was and is in sections 2 to 7 of the 2018 Act. So that's the first chunk of law left over from our membership. And the second, of course, is withdrawal agreement law, which is given domestic effect by section 7A of the 2018 Act. The court has section 7A at tab 3, page 10 of the authorities bundle, but I don't think we need to turn it up. But that's the framework. Free movement law did not take effect as retained EU law. So in order to have domestic effect, it either has to be applied by the withdrawal agreement or otherwise given some domestic effect. So could the court turn to tab 1 of the authorities bundle, and this is the Immigration and Social Security Coordination EU Withdrawal Act.
I'm still unpicking that last sentence,
Yes.
because you've added a label, which is your label, free movement law. So I can't remember the articles, but wouldn't section 4 have allowed people to rely on the free movement provisions? Wouldn't they allow somebody to rely on the Article 20 provisions? Because section 4 didn't go until recently, I thought.
Yes, that's what I'm just about to show you.
Okay.
Yes, because it did not take effect as retained EU law for the reasons that
Right,
I'll show
okay,
the court
yeah.
now. So tab 1, Immigration and Social Security Coordination EU Withdrawal Act 2020. Section 1, repeal of the main retained EU law relating to free movement, etc. Schedule 1 makes provision to end rights to free movement of persons under retained EU law, including by repealing the main provisions of retained EU law relating to free movement, and end other EU-derived rights and repeal other retained EU law relating to immigration. So, had this Act not been enacted, EU free movement law, as your Lordship quite rightly observed, would have been sucked into domestic law via sections 2, 3 and 4, but this Act stops that from happening. So,
And it includes Article 20 as well, does it?
yes.
Citizenship.
Yes. So, the problem, and it may help the court to have the historical version, the problem is that because section 4 has now gone, the live version of this Act has taken some bits out. But if one looks at this Act as it first came in, it did deal with those various things. So, section 1, and then consequential provision, there's a power in section 5 for making secondary legislation. So, section 5.1, the Secretary of State may by regulations made by statutory instrument make such provisions as the Secretary of State considers appropriate. The consequentials SI is made under this power. The power to make regulations under subsection 1 may, among other things, be exercised by modifying any provision made by or under primary legislation, retained direct EU legislation, which wasn't necessary here. And then 3, the power to make regulations under subsection 1 includes power to make supplementary, incidental, transitional, transitory or saving provision, and to make different provision for different purposes. And then there's a special provision for the first statutory instrument, which the consequentials SI wasn't. It's subject to annulment, so it's negative resolution procedure, that's 5.8. And then 8.5, over the page, dealing with extent. Regulations under section 5 may provide that an amendment, repeal or revocation made by those regulations has the same extent as the provision amended, repealed or revoked. And then the court has what's left really of Schedule 1. Paragraph 1, which the court doesn't have, omitted Section 7 of the Immigration Act 1988, which was the old exemption from requirement to have leave to enter or remain. And then Schedule 1, Para 2.2, the 2016 regulations are revoked. But as I say, there was more to this. Perhaps I can get that brought to court this afternoon, if the court would find it helpful to see how, when on 1st of January 2021, what this Act did at that point. So originally it had provision about what would have been direct legislation under section 4. So that's ISCO, if I can call it that for short. So a Zambrano person has to, the Article 20 right has gone because the UK has left the EU. It comes from Article 20. We've left the EU and UK citizens are no longer EU citizens, so they can't assert Article 20 rights as against the EU. If you need authority on that proposition, it's at footnote 7 of our reply skeleton, but it's not controversial. So in order for anyone who had previously enjoyed a Zambrano right before the end of the transition period to carry on residing lawfully after the end of the transition period, they either needed something in the withdrawal agreement or something in domestic law. The right is not preserved by the withdrawal agreement. The withdrawal agreement's in tab 15 of the authorities bundle at page 283. We've only included part 2. Part 1 is addressed in Shellick at paragraphs 21 to 24, but we don't say there's anything the court need look at there. Article 10 on page 284 deals with the personal scope of the withdrawal agreement, and Zambrano carers are not covered. So the key point to look at, first of all, is Article 10.1. Without prejudice to Title 3, that's about social security coordination, this part shall apply to the following persons. It's union citizens who exercise their right to reside in the UK. So you've got to have, you're in the UK but you're not a UK national, in accordance with union law before the end of the transition period, and continue to reside there thereafter. And then UK nationals who exercise their right to reside in a member state, so that's not the UK now, in accordance with union law before the end of the transition period, and continue to reside there thereafter. You then get in Article 10(1)(e) a raft of provisions for family members. So Article 10(e)(1), they reside in the host state in accordance with EU law before the end of the transition period, so they're already here, or they're directly related to a person referred to in points A to D. So that's an EU citizen who's been exercising their rights in the host state, and they resided outside the host state before the end of the transition period, but, so they haven't made any use of their family member right, but the EU citizen has been exercising rights before the end of the transition period. And provided they fulfil the conditions set out in Article 2.2, at the time they apply, they are also within scope. And then there are some other more detailed provisions there that I don't need to take the court to. Just to understand what host state means, we look at Article 9C, 283. Host state means in respect of EU citizens and their family members, the UK, and in respect of UK nationals and their family members, the member state in which they exercise their right of residence. So what these scope provisions are doing is two fundamental things. First, it doesn't preserve any right for Zambrano carers, because to fall within scope, you need to have exercised rights in a host state, which is not your member state of nationality, because host state is for union citizens the UK, and for UK nationals it's the member state. So what it doesn't do is allow somebody to assert ongoing residence rights on the basis of Zambrano as against their home member state. So as far as the withdrawal agreement is concerned, Zambrano carers have lost their rights as of the 1st of January 2021, and it's up to the member states whether they do anything about that. And that includes those who are already exercising the right.
There's not people who would like to come here after the 1st of January. You're saying it also covers those people who were here. The mother
Yes.
of the child would wake up on the 1st of January with an immigration officer at the door saying, "Time to go, darling."
Yes, but not what the Secretary of State
putting
did,
it, yes.
because the Secretary of State chose to make domestic
But that's the
decisions.
key question then, is whether the United Government, in the warmth and goodness of its heart, decided that would be
Yes.
harsh.
Yes, and it did, but only for those who were exercising the right at the end of the transition period, or by virtue of a later concession where the child, the sponsor, in effect, was here by the end of the transition
That's the key
period.
question, is what the government did
Yes.
for people who were caught because they hadn't been able to get through the door before the
Yes.
31st of December.
Yes.
Yep.
So that's the first point. The other point I would make about scope is that the withdrawal agreement, as I've shown the court, is premised on some sort of exercise of rights by an EU citizen at the end of the transition period. There might be some additional conditions, but at the very least, there has to have been something that has happened in terms of the exercise of rights by the end of the transition period by an EU citizen. So that's the withdrawal agreement. The other thing I just invite the court to note in the scope provisions is that there is express provision in Article 10.3 for people who've applied before the end of the transition period as extended family members. So there's nothing in the withdrawal agreement that says, but if you've applied for a Zambrano right before the end of the transition period, you can still get it. That's only there for extended family members, Article 10.3. And the reason that's there is because extended family members are eligible, as explained in Chellick, to apply for the new resident status. But Zambrano carers, under the withdrawal agreement, their rights have gone. That's not controversial. I don't need to ask the court to turn it up, but it's accepted by the Commission, unsurprisingly, given the terms of the withdrawal agreement, and that's in the Commission notice at tab 22 of the authorities bundle, page 441, paragraph 1.2.2.2.
Right.
So just drawing those points together, we say that it's important context to the construction argument in this case that the UK has left the EU, that the treaties no longer apply in the UK, that under primary legislation, the 2020 Act, at tab 1 that I showed the court, EU free movement rights do not take effect as retained EU law. That the withdrawal agreement preserves some EU law, but not the Zambrano right. So it doesn't come in under section 7A. And then finally, even where the withdrawal agreement does preserve EU rights, it specifically requires that there's been some exercise by an EU citizen of their free movement rights by the end of the transition period.
So the withdrawal agreement does that.
Yes.
But it's irrelevant here because the withdrawal agreement doesn't preserve any Zambrano rights.
No, although we say it's part of the picture, and it's certainly part of the picture, is the grace period SI, but by far we would submit the bigger part of the picture is the primary legislation, which does not take these rights into domestic law as retained EU law, and which basically says we've left the UK, we've left the EU. So that, we say, is the context against which the consequentials SI falls to be construed. Now, given the retrospectivity and fairness arguments that have made, I just want to show the court what was said about Zambrano rights by the UK at an early stage, and that's addressed in our reply skeleton at paragraphs 11 onwards. Could I first just show the court the EU settlement scheme statement of intent, which is in the summer of 2018, and that's at tab 20 of the authorities bundle.
And this is going to help us interpret the regulations how?
Well, I can leave this to replies, but a fairness retrospectivity point has been taken, and I'm saying, well, it was made clear what the position was. So, paragraph, this is just an extract from it. Paragraph 6.10 on page 429, it says there are certain other categories who have a right of residence, not under the Free Movement Directive, but under wider EU law, and will have their residence rights protected by the withdrawal agreement in line with their current rights. And
I'm really sorry, because I was trying to make a note of what you said, I haven't got the paragraph.
I'm so sorry.
I'm really sorry.
It's tab 20,
Yeah.
paragraph 6.10.
Right,
So
okay.
it's just to read the next paragraph in context. This is saying some derivative rights people have their residence rights protected by the withdrawal agreement, and that's Chen and Ibrahim and Tashira. That's paragraph 6.10. And then 6.12 says, we've decided as a matter of domestic policy, and then it's the second bullet, a non-EU citizen who's the primary carer of a British citizen in the UK and currently derives the right of residence from wider EU law will be provided for in the immigration rules. Further details we've provided in due course. So this is in June 2018. The draft withdrawal agreement is published in November 2018, and then the EU settlement scheme is formally introduced in March 2019, and that's when the UK says what Zambrano carers need to do in order to enjoy a right under our domestic law. So this is dealt with in paragraphs 12 and 13 of our reply skeleton. Could I just ask the court to look at tab 13 of the authorities? This is the statement of changes in the immigration rules.
13.
Tab 13. So this brings in new domestic residence rights for Zambrano people. So 3 references in here to show the court. Page 37 at authorities 227. It depends which page number. The page number in the middle is 37, bottom is 227. Eligibility for limited leave to enter or remain. EU 14, condition 1. The applicant meets the eligibility requirements for limited leave to enter or remain where the Secretary of State is satisfied, including, where applicable, by the required evidence of family relationship, that at the date of the application, condition 1 or 2 set out in the following table is met. The condition is 1A5, a person with a Zambrano right to reside.
Yes.
Page 51, authorities 241 defines a person with a Zambrano right to reside. And that's a person with, by the specified date, a right to reside in the UK by virtue of Regulation 16.1 of the regulations by satisfying the criteria in paragraph 5 of that regulation or paragraph 6C. And that's for children, siblings, and without leave to enter or remain granted under another part of these rules. When does the person have to have had the right to reside? What is the specified date? That is on page 57, authorities 247. And we only need to look at A. If the UK withdraws from the EU with a withdrawal agreement 2300 on the 31st of December 2020. So under these rules, in order to be a person with a Zambrano right to reside, you need to show that by the specified date, in other words 11 PM on 31st of December 2020, you had a right to reside in the UK by virtue of Regulation 16. So you're not going to be able to benefit from this if your right to reside starts on the 2nd of January 2021.
What happens if you apply and should be, because we've got the right to enter and you can't enter, so you can't acquire an actual period of residence until you've entered, got admission to the United Kingdom, but we know that you would be entitled to a right to enter, admission, because you would be entitled to reside, and you would have been entitled to reside at any time up until the end of the transition period. So between March 2019 and the 30th of December 2020, you can get admission, you can come in and everything will be okay. But what happens if the Home Office doesn't deal with the applications for whatever reason, say they've got too many more than they expected? You've then got to have something that shoehorns them in, and you could do a number of things. You could say, well, we'll put them as if they were under the old regime, even though they're coming in afterwards. Or you could say, well, that's tough. I know we've been slow, but you and your child get they gone. They could have been one of two things, couldn't it, at the moment? We don't know the answer to the question yet.
Well, the answer to the question is they're certainly not going to be able to succeed under the EU settlement scheme because that is what the rules say, and save for the concession.
I understand that. That's why I'm saying
yes.
This is predicated on the assumption that everything has happened in the 19-month period between March 2019 and December 2020. And the key question is, what if it doesn't?
Yes.
And that's what we need to go to
Yes.
next, I suppose.
Can I just ask, page 51,
Yes.
what you've got to demonstrate at the specified date, by the specified date, which means by the, is that you have the right.
Yes.
Not that you're exercising the right, but you have it.
So you had a right to reside by the specified date.
Yes. So that you look at Regulation 16, under that, do you, by the 31st of December, have the right to reside? So where do we get from that you need to be exercising the right to reside?
Can I just turn my back for a moment in case I've missed something in the red? I mean, certainly the British citizen, the way that it's interpreted, and certainly as I understand it, been accepted to work, is that you need the right to reside. You need to be here exercising the right by the end of the transition period.
Well, that's not what it says.
And the British citizen child needs
Yes.
to be here.
It doesn't say you need to be exercising. It just says you need the right. And you've been, if I might say so, somewhat labouring the point, regulation that it's declarative, not the documents.
Yes.
So that I just, speaking for myself, at the moment this seems to be saying that provided you have the right by the date, and it's actually at the date of the application, so it's not even by that date. It really means you're looking at it as at the date of the application to see whether, I mean, obviously if the application is after the 31st of December, this wouldn't apply, but if it's before, all you have to demonstrate is that you have the right to reside. Yes. By virtue of Regulation 16.
Yes, there may be. Can I just take instructions over lunch, because there are also only some people who can enjoy, for example, leave to enter. There are provisions about leave to enter rather than leave to remain. But I will just take instructions on that point, if I may. Can I just show the court briefly the explanatory memorandum?
Sorry, why were you showing this? I wasn't quite sure. This is part of the background.
Yes, because a point has been taken by the advocate, which I understand is still pursued.
The fairness point.
Retrospectivity and fairness. And my counterpoint is, A, it was made clear what the position was, and my second point is that if one construes everything as a whole, including A, the fact that we've left, B, the fact that under the immigration rules you need to have at least, now under the concession, had a child here by the end of the transition period, given all the other interpretive factors that I'll point to, that it doesn't make sense to construe the consequentials SI in the way that's being suggested.
I mean, as you can see from the way I'm just reading this, it doesn't seem to support your retrospective argument. It seems more to support Mr. Pobjoy's point.
Yes.
In other words, this appears to be saying it's not retrospective because it's the date of the application, effectively. You have to show that you have the right under Regulation 16.
The application, in a sense, if you this is because obviously the rules have been changed as time has gone on. These are the pre-end of transition.
Don't worry, I understand that. Well, yeah.
So I think your Lordship's point is, well, this allows you to say, I'm not here yet, but in fact I would have enjoyed the right had I been there.
No, you don't have to be here
to
enjoy the right under Regulation 16.
Yes, your Lordship's point is that under page 57, because it says all you need is a right to reside in the UK by virtue of Regulation 16.1, by satisfying the criteria, that means that if you apply on, say, the 30th of January 2021, and you can show that had you been in the UK, you would have enjoyed that right.
No, that's not what I'm saying. I'm saying, if you go back to the page 37, this says you've got to demonstrate certain things at the date of the application.
Yes.
And we're assuming for the moment, because of the specified date, the date of the application has to precede 31st December 2020. And what you have to prove is that you have you're a person with a Zambrano right to reside. That is defined as being that by the specified date, that is obviously the end of the transition period or implementation, you have a right to reside by virtue of Regulation 16.1. Just you have it. Not that you're exercising it, you have it. That's all. That's the only point I'm making.
Except that if you look at 16.5, which is specifically referred to in this thing on page 51, 16.5 says, person's primary care is a British citizen, BC is residing in the United Kingdom.
Yes. I think that was the point that my junior was just
But
directing to my attention.
I understand that, but you've already said that doesn't apply, because if it did apply, you would never have a Zambrano right as we're discussing it, and you say it's been recognised that it does exist.
Yes, but there is language in Regulation 11 and 12 to that effect.
Yes.
The oddity is that you've got 11.5e. That's the difficulty. You allow people, you have decided as a government to allow people to come into the United Kingdom with a British national child. So by definition, it isn't just to get admission that you are residing here. To get the right to admission, you must be able to enter here. This is talking about limited leave to enter or remain, but it's hard to square that with Regulation 11.5e, because I think they seem to be thinking of you'll come in and then you'll reside. And the problem is they can't come in quickly enough because you aren't processing their applications before the end of the transition period. And if you're looking at fairness of what the government is intending to do, they might be doing what you're saying. Well, they haven't got in time, therefore they've got no right. Another thing they might be doing, and this is what we've got to look at the regulation for, is to say, well, actually, as at the date of the application, they did meet everything. And we aren't going to say they are going to be treated in the same position as people who first attempted to come in after the end of the transition period. We are going to say those who attempted to come in and had a right to do so will be treated like people who managed to get in before the end of the transition period. That's the key question, I think.
Yes, and to some extent that was done by the concession, but as a matter of concession and then in the rules.
Well, you've got to look at the rules first and work out what the government intended. The concession isn't going to help us interpret the rules. And neither does this answer the question, because the $64 million question is, what was the intention in relation to people who had applied and met all the relevant boxes for the application that they made, which is to enter, but you haven't processed it?
Yes, and I accept the answer to that is to be found in the consequentials.
Yeah.
Yes. Can I just finish off this point by showing the court tab 12?
Before you leave this tab, was this the one in place at the time when the applications were made?
I think so, but I need to check.
Double check
We've got
that,
other
just so we've
versions
got the
in
right
the
one,
book.
yeah.
Yes.
Just tell us after lunch which one is.
Yeah,
Yeah.
just to be clear though, the applications were not under this provision.
No, I understand that,
They were,
but I want to know which ones were in
Yes,
place. The
yes,
applications were
understood.
made under the rules in force. But again, the oddity is you've got to get in under the rules, and then you've got your documents or your status, which you transfer to the new EUS scheme.
there's two different things. So there's the application under the 2016 regulations, and
Yeah.
then there's the application under the EU settlement
Yeah.
scheme. Zambrano carers, as I understand it, and I'll be corrected if I'm wrong, have never been able to make an out-of-country application under the EU
So
settlement
that's
scheme.
why they've got to get in the first place.
Yes.
That's why they're applying for a family permit.
Yes.
They need to come in.
Yes. Although
Right.
This, yes,
Tab, which tab?
Yes, tab 14.
Thank you.
Page, which starts at page 263,
Yes.
and then the final bullet of paragraph 7.65.
7.65.
7.65
Yes.
is just an explanation. Now, I accept it doesn't. This doesn't help in terms of construction, but again, I'm in terms of the fairness point and what the government thought was fair, is that it's really the final sentence. It's Zambrano carers, in light of the particular circumstances of these cases, it's appropriate that their long-term status in the UK should be protected.
Yes.
I'm sorry, I missed the reference to that. It's my fault.
7.65 final bullet on page 277.
277, thank you. Sorry, I missed it.
There's the lawfully resident in. Yes.
So with that then, can I turn to the grace period SI, which is at tab 7. Now I deal with this one first. It was made first in time. It was made on the 3rd of November 2020. We did hand up, because the court doesn't have the introductory preamble or
What's it called?
Regulation
It's
1. Citizens' Rights Application
Yes,
Deadline and Temporary
1209.
Protection. So it was made under Section 7 of the EU Withdrawal Agreement Act 2020, and that the court doesn't have it, but that's a power in relation to specifying a deadline for the purposes of the withdrawal agreement for making a residence application, and also implementing Article 18.2 of the withdrawal agreement, which is protecting people in the grace period. So that's the power for this, and the deadline is on page 33, Regulation 2, 30th of June 2021.
Not that it may not be relevant. I thought that was extended by some provision, or it was not enforced.
It was enforced.
Because I know certainly in respect of children who were resident here, it wasn't. My understanding is it wasn't enforced, and applications could be made.
They can be made if there are good reasons. There's specific provision in the withdrawal agreement. If there's good reason for a late application, it can be made late.
Yeah.
Yes.
So, and this is an application for resident status, which by definition must be an application under the new EUSS, must
Exactly.
it? Yes. It can't have been an application under the 2016 regulation.
No, this is about setting that grace period, and it's about providing for the position of people before they make such an application, and once they've made the application before it's determined. So Regulation 3, grace period, this is during the period up until the 30th of June 2021. So 3.1, this regulation has effect if the EEA regulations are revoked on IP completion date with or without savings, which they were, as we've seen. The provisions of the EEA regulations specified in Regulations 5 to 10 continue to have effect despite the revocation of those regulations, with the modifications specified in those regulations in relation to a relevant person during the grace period. And then 3.3 and 3.4 make provision in respect of other provisions that apply in Regs 11 and Regs 12. So who is a relevant person? That's defined on page 35, the last definition. So it's a person who doesn't yet have leave to enter or remain in the UK, and who, A, immediately before...
Sorry, that's not right. Doesn't have leave to enter or remain in the United Kingdom by virtue of residence scheme immigration rules, i.e. they haven't got a EU family permit one. It still doesn't deal with the 2016 regs. It's not.
No, I accept that.
Yeah.
It's just dealing with this cohort, because your lordship asked me about the circumstances in which regulation of derivative residence card might continue to apply. So this is an example. So what is a relevant person? Who are these people that get the ongoing benefit of the regulations which are specified in the provisions to come? It's a person who doesn't have leave to enter or remain, so just leave to enter or remain, and who, A, immediately before IP completion day, 1, was lawfully resident in the UK by virtue of the 2016 regulations, or 2, had a right of permanent residence in the UK under those regulations. And then there's some provisions for family members. So a person with a derivative right of residence under Regulation 16, whether or not they had a piece of paper, who was lawfully residing in accordance with Regulation 16, is a relevant person for these purposes and falls within scope of the grace period, SI. This SI.
Sorry, can you say that again?
Yes. So if somebody, it's the definition of relevant person.
Yes.
If somebody was lawfully resident in the UK
Yes.
at the end of the transition period under Regulation 16
Yes.
of the 2016 regulations, they would be a relevant person
Right.
for
Yes.
these purposes.
Okay.
So that would include a Zambrano person. And then Regulation 4, that kicks in after the end of the grace period. And that's 4.2, while you're waiting for your application to be determined. And this mirrors the provision. So rather than being called relevant persons, they're called applicants. And they are those who've made an in-time application and immediately before IP completion day were lawfully resident in the UK by virtue of the EEA regulations or had a right of permanent residence. So again, a Zambrano person who was lawfully resident as a Zambrano carer on the 31st of December 2020 and who has made an application under the EU settlement scheme is protected under this regulation as an applicant.
And this regulation is dealing entirely with people who are lawfully resident. It just isn't dealing on its terms with people who haven't entered
No,
yet.
no. But we say it's relevant to note that it preserved some provisions that the consequentials SI, we say, deliberately did not preserve. So Regulation 5 includes various definitions. And these are definitions which, by and large, with minor changes not relevant to this case, are also preserved by the consequential SI. And then Regulation 6 on page 42 specifically retains provisions relating to residents' rights. Now note, Regulation 6A, Regulation 11, right of admission, is retained. So somebody who was lawfully resident retains their right of admission, so they can come back again, but those modifications there are modifications which take out the ability to prove that you have a right without documents. So I can show the court that, but that's what those modifications do in Regulation 11. So for relevant persons applicants, they continue to have a right of entry, right of admission, but they have to have a document to be able to do it.
Right. Can I just check which group of people this is dealing with? Is this only dealing with those who were lawfully resident in the United Kingdom
Yes, it's
before the end of the 30th of December, have left for whatever reason, and are returning to the United Kingdom?
Exactly.
Then they can return, but they must now have a piece of paper.
Yes, they must now have a piece of paper. That's the modification.
So it's still not dealing with those who never got here first. Okay, right. Yeah.
None of this is dealing with people who didn't get here first. But we still say it's part of the same package of material and legislative material, and it's relevant to see what it does and doesn't include. Regulation 12 is also retained. The exclusion there relates to extended family members, so it's not relevant for present purposes. But again, this only helps somebody who was lawfully resident at the end of the transition period.
Yep.
And because it's retained, such a person, so a person falling within these regulations, they can make an application for an EEA family permit after the end of the transition period. Because Regulation 12 is kept. What isn't kept by this regulation is Regulations 17, 18, 19 and 20, which are the provisions dealing with residence documents under the 2016 regulations for people who are here. So what this does, because it preserves only Regulation 12, but not Regulations 17, 18, 19 and 20, and we've looked at Regulation 20, after the end of the transition period, anyone in this cohort can make an application for an EEA family permit, and that might be precisely the reason your Lordship just identified. They need to get back again. They need to go and come back again. But they're the only ones who can make an application for documents.
What about the person who's come here, has been lawfully resident here, and wants an EU residence card? The answer is it's not relevant after the end of the transition period. After the end of the transition period, Regulation 20 doesn't help you because you should be going into the EUSS scheme after the end of the transition period.
Yes, so are we talking about, say, a French citizen just residing in the
No,
UK?
I'm a Pakistani woman or a Nigerian man. I've got a British child,
Okay,
and they're here. I'm here with them,
yes.
and in December 2020, I want a Regulation 20 residence card, and I apply for a Regulation 20 residence card. I can't get it under this regulation because it's not been preserved.
Yes, so what you have by virtue of this regulation, and I'm just coming to that, is looking at F, you still have the right to reside under Regulation 16.
But I can't insist on a residence card, a Regulation 20 residence card under this regulation.
Under this, no, but that's where the consequentials SI
Exactly.
helps you. Yes,
Yeah.
exactly. So I've dealt with Regulation 12, but as I say, the only application that can be made after the end of the transition period is an EEA family permit, because the others aren't preserved. So regulation 12 is preserved, 17, 18, 19 and 20 aren't. Doesn't answer that those applications made before the end of the transition period can continue to be considered. See the consequentials inside.
And the reason why you want an EEA family permit is if you're going to make an application for limited leave to remain under the new EUSS scheme, you've got to have as one of your documents something like an EEA family permit.
If you're an extended family member, yes.
Yeah.
Not if you're another sort of person.
No. Yeah.
Yes, but yes, those exactly. They will definitely need one. Yes.
So I can see a reason for it. Yeah.
Yes. Yes.
Gosh, thank goodness it's simple.
So easy. So or for example, another reason regulation 12 is there is that somebody who's residing lawfully and hasn't yet got their US leave, was residing lawfully at the end of the transition period, for example, the Nigerian national might need to leave and come back again.
Yeah.
So there is a reason for preserving that, but not the others.
Yeah.
So yes, and as I say, all this, it's important, C, D, E and F, this regulation, unlike the consequentials SI, preserves expressly all the rights of residents. So it preserves regulation 13, the initial right of residence, that's the first 3 months, regulation 14, which is the extended right of residence, regulation 15, which is the right of permanent residence, and regulation 16, which is the derivative rights to reside. So that's why we say, for people who fall within this regulation, they can be issued with documents after the end of the transition period, because it's meaningful, because they have got that right of residence, that's the meat that's given to them here. Those substantive residence provisions are continued, but only for that cohort.
Under this regulation?
Under this regulation. When it comes down to it, the issue with the consequentials SI, and the court will be making this decision, is does Reg 11 trump the absence of Regulation 16, or does the lack of reference to Regulation 16 trump Regulation 11? I'll deal with that, but in effect it's a short point.
It is a short point, yeah.
It's not an easy one. So there are various other provisions. We did hand up the clip. I should just note that what Regulation 9 does is preserve the Regulation 36 right of appeal, but it modifies the ground of appeal. So that rather than arguing about breaches of treaty rights, you have to argue that there are breaches of the 2016 regulations or the withdrawal agreement or some other separation agreement. So that's what I was proposing to say on the law, and now we come on to the part that everybody's been waiting for, the consequentials SI, which is at tab 5. Now again, we did just hand up the preamble and so on, so the court could see that this was made 14 days after the grace period SI. So it was made on the 17th of November 2020, and it's made under the powers that I showed the court in the Immigration and Social Security Coordination EU Withdrawal Act, and that can be seen from the face of the preamble. So this provision is made in the context of the UK having left the EU. I won't repeat my provisions of context, I've already made them. So Regulation 82, Schedule 3 has effect, and then we come to Schedule 3. Paragraph 1 is simply saying the EEA regulations, if they had effect immediately before they were revoked, and that's what we handed up. Paragraph 2 is dealing with deportation and exclusion.
So hang on.
orders.
EEA regulations 2016 means the 2016 regs as they had effect immediately before they were revoked.
Yes. So they were revoked by the Act that I showed the court at tab 1. They were revoked
On the 30th of December 2020.
So,
But this is pretending that the regulations before they were revoked.
so when it's making references, because obviously once they're revoked, there's nothing left. So although they've been revoked, some bits of them survive as applied by both the grace period SI and this one.
But it's two things, isn't it? The first sentence, the first line identifies them. We know which document to look for. The document headed EEA Regulations 2016. And the next bit says, and unless provided otherwise, refers to those regulations as they had effect immediately before they were revoked.
Yes.
They're describing the effect they had prior to revocation, not the effect they have after revocation.
Yes, I accept that.
Mm.
Yes. But we say that's simply a drafting device to make sure that you're not getting a blank regulation. It has to be the regulations as they had effect immediately before they were revoked.
Yeah.
So then the two key provisions, regulations 3 and 4, we say they do two different things. So regulation 3 is called pending applications for documentation under the EEA Regulations 2016, and regulation 4 is about the application of the EEA Regulations 2016 to pending applications. So paragraph 3, we draw attention to the words that appear in every bit of this, which say the regulations, blah, 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 named here, continue to apply for the purposes of considering and where appropriate granting. So what Regulation 3 is doing is introducing the idea that there will be circumstances in which it's not appropriate to grant an application simply because it's been made before the end of the transition period. So what paragraph 4 does then is set out which regulations are specified for the purposes of determining whether an application referred to in paragraph 3 should be granted. So we say these two provisions are doing different things. The first one is about being able to consider the application, and the second one is fundamentally about the substantive question of whether the application can be granted. And we say that the words where appropriate appear because it's recognised, and that's consistent with the 2016 regulations as they applied before the end of the transition period, that where there is no underlying entitlement to enjoy a right, then it won't be appropriate to grant the document. So we showed the call Regulation 11, which says you need the document and you also need to be meeting the conditions. We showed Regulation 12, the similar effect. We say that where appropriate is consistent with the scheme of EU law in the 2016 regulations, which is about meeting conditions.
But you're applying them, the 2016 regulations, as they were before they were revoked. And we know from 11.5e, that old regulation, that if you applied them as they were before they revoked, somebody would be able to get a right of admission even though they hadn't yet come here. We know that's not been dealt with by any other set of regulations. So why isn't the natural interpretation that this fills in the gap for those who had applied for admission before, hadn't been granted permission before the end of the transition period, but were entitled before to the end of the right to admission?
The short answer is because Regulation 6 does not preserve the underpinning residence right. So turn to Regulation 6, Authorities 22, turn over the page to Authorities 23 and note the big and glaring omission, unlike the grace period SI. to retain the effect of regulation 13, 14, 15 or 16.
But you're not dealing with 16. We've just gone through that. You're dealing with would be entitled to. You're dealing with 11.
But we say if you take away the right of admission relies on being able to be admitted because you have a substantive right. And you don't have the substantive right if the substantive right is no longer in effect. I mean, that's the short point.
Yeah, but the oddity is, I fully accept that you'd expect somebody to be able to be admitted and then to enjoy residence rights. The oddity about this, I'm afraid, is it seems to say on its terms that they've preserved the right to be admitted, so they'll get in, but there is a gap then as to what happens. They've been lawfully admitted, and you haven't said yet what's going to happen to them. They don't now have any rights after admission to continue residing under the withdrawal agreement, so you were never obliged to give them that right. And one wonders what the Secretary of State was going to give them. What would be their position if they had been, say the application was processed at 1 minute to 11 p.m. on the 30th of December. They were at the airport and a Home Office official was rung up, stamped the family permit. They could come in at 1 minute to 11, couldn't they?
So
what would happen to them next?
Two things. So first, Regulation 11 is preserved for quite a specific purpose. There's not a right at large to enter for this cohort. There is for the grace period SI cohort.
Yeah, but we're not into that. We're into this regulation.
I know. It's retained for the purposes of determining whether an application referred to in paragraph 3 should be granted.
Yeah.
At this end, and I'm afraid that we can't answer this question, and we hold our hands up. We do not at this point understand why Regulation 11 was retained. And that we've accepted that in writing. We have looked back and I can assure the court that a lot of work has been done, unfortunately, because of what happened at the end of the transition period. A lot of these regulations were drafted without written instructions. The person who drafted them is no longer there. We don't know why the person thought that, we can't get into their mind and understand why they thought that for the purposes of considering an application, it was necessary to preserve Regulation 11.
Well, those words must have meaning. When the Secretary of State made these regulations, it was the Secretary of State made them, presumably.
Yes, it was.
Well, she must have intended to do something. Secretaries of State don't just go off on whims. That would be unheard of.
Well,
so what did she have in her mind? She's preserved the right of admission for somebody to be treated as if they would have been entitled to a right to reside. If they can't come in, that bit of Regulation 6 is completely unnecessary. What does it preserve?
Yes.
Nothing.
Yes. Our position is we cannot at this point explain why a decision was made to retain Regulation 11, because in our submission it is otiose without, I called this earlier, the wind beneath its wings, but it is the best way in my submission to understand it, without the underpinning residence right. That Regulation 11 always reflects some underlying right to be here. Otherwise, there's no free-floating right of admission. There's not sort of a system of visitor entry under these regulations.
No.
The core function of admission is because you enjoy a right to reside. And we see in the grace period SI, those rights of residence are preserved. And it is striking, and we say absolutely deliberate and not an accident, that those rights of residence are not preserved in this SI. They're not there. And so that leaves Regulation 11 without the wind beneath its wings. Because Regulation 11 is meaningless if you don't have a substantive right to reside. I can't answer the court's question any better than say I'm afraid I can't explain it. I think it's an error.
When they come in, well, we quite a lot of tests before we can say that a Secretary of State has erred, because she's a very careful person and she'll have taken lots of legal advice. So they're heavy tests to show a Secretary of State's erred. They never do that, or very rarely. So the position is, though, they might have thought, well, let them in. If only we processed the applications in time, they'd have been in, and we'll sort it out later.
Well,
Is that a possible approach?
it's not impossible, but we say it's not the right approach. If one's factoring all the different factors into the mix, and I'll draw them all together in a moment, but if all the factors are taken into account, including the context of leaving, including the context of primary legislation, we say that if the Secretary of State was going, in effect, to be letting people in without actually giving them any right to be here, that would have, if what the Secretary of State was doing is saying, come in, then that would need clear language given the context, which is we've left and they haven't got any right to come in. And there isn't clear language. There's here, and we accept it's not clear what that reference to Regulation 11 is doing. But what the Secretary of State's done is taken away the residents' rights, so there's no point in letting people in.
Well, what's the purpose of Regulation 3.6 was the next question.
3.6.
3.6.
That's the answer that I gave your lordship earlier, which is those within the grace period SI could have made an application for a derivative residence card on the 30th of December 2020, and they could be issued one. And the reason that they could be issued with one is because they still enjoy the Regulation 16 right. That's my wind beneath the wings point. So for that cohort in the grace period SI, they can have a derivative residence card because there's a point to giving it to them, and the point is that that Regulation 16 right is continued in effect for them by the grace period SI.
But not by this regulation, because when you go to Regulation 6 again,
But
Regulation 20 doesn't.
But that's
Regulation 16 doesn't feature.
but that's the where appropriate they can be granted it because they have a right of residence under another provision, which is the grace period SI. They have that right. They don't have it under this, but they don't have it under this because they don't this for that cohort. This is just the right to issue documentation.
But why do they need it under this regulation if they can get it under the other regulations?
They can't get the document partly because the grace period SI has a very specific function. Remember, it's VIRES. It's about dealing with people lawfully resident while they make an application and dealing with their position. For whatever reason, it doesn't deal with the issue of domestic documents. For that cohort.
The grace period relates to applications made from the 31st of December to the end of June. Does it apply to an application made before the 31st of December?
But depending, it applies, what it does is give somebody rights to reside in the interim before they make their use application and while their use application is being considered. It depends what your lordship means by application.
Could I make an application before the 30th of December 2020 to which the grace period regulations applied?
But what sort of an application?
Could I, well, then rather, I want a Regulation 20 residence card. I could apply for that prior to the end of December 2020.
Yes, under the 2016. Okay.
If I don't make the application until the 1st of January 2021, can that application be considered under the grace regulations?
No, because remember that only Regulation 12 was preserved, and therefore
And not 20.
And not 20. So that's why when you look at paragraph 3 of Schedule 3, the only application that's envisaged to be made after commencement day is the Regulation 12 application. See para 3.2, because that picks up and chimes with the fact that the grace period SI preserves Regulation 12 and therefore allows an EEA family permit application to be made after commencement
So
day.
I've applied for a Regulation 20 permit before the end of the period, before the end of the transition period. It can't be granted under the grace regulations, and it would seem that any preservation of anything under the grace regulations period would therefore be irrelevant. So by preserving the possibility in 3.6 for Regulation 20 to apply, but not having Regulation 16 in the Rule 6 provision, either 3/6 is enough to carry forward the entitlement implicitly to satisfy the conditions in 16, or it's hard to see why 20 is there, or you say where appropriate means even if they can get something to do with rights of residence, but it could never apply to the card that they're applying for under this regulation, that's enough.
Well, the Secretary of State would say if that application is made on the 30th of December and the person was residing in accordance with Regulation 16, they still have that right of residence under the...
Not when the
that's
application is considered.
When the application is considered, if that person has a right of residence under Regulation 16, which they will do if they're within the grace period cohort, then that derivative residence card will be issued because they have the underlying right. So
But the grace period doesn't give them the right to the Regulation 20 card. You're taking the fact they could get something else under the grace period.
But it's...
The application for the status under the EUS scheme is what they apply for, I thought. But you're saying, well, because they could apply for the EUS scheme within the 6-month period,
No.
therefore they can get the Regulation 20 card.
No, I'm not saying that. Because, what I'm saying is because the grace period SI preserves the substantive Regulation 16 right of residence by virtue of the fact that they've made a different application. But that's a bit of a red herring so far as this point is concerned. Because the grace period SI preserves their substantive right of residence, there is a reason to be giving them a derivative residence card.
Well, hold on, could you just show me the grace period regulations again? I thought it was for residence scheme permits, the new thing. Where is the grace regulations again in this master document?
It's tab 7.
Yeah.
It does two different things. It gives you a grace period to make your use application.
Yeah.
And in the meantime, it gives you substantive residence rights under the 2016 regulations. So it's doing two different things.
And where's the bit that says they continue to have their substantive rights preserved?
It's Regulation 6, page 42.
Yeah.
The following provisions of parts 2 and 3 of the EEA regulation.
16, yeah. Okay.
And 13, 14, 15 as well. So those...
But they're specified for the purposes of Regulations 3 and 4.
Those are specified for the purposes of Regulations 3 and 4. And those purposes, if we just do the grace period 1, Regulation 3, the purpose is that those provisions of the EEA Regulation 2016 specified in Regulations 5 to 10 continue to have effect with the modification specified in relation to a relevant person during the grace period. So during the grace period, a relevant person continues to have the benefit of the substantive residence provisions in the 2016 regulations.
Well, that's your statement of the conclusion. 6 says the following provisions apply as specified for the purposes of Regulation 3 and 4. 4 is just about applications, isn't it?
It's about... No, it's... So what this does is cover two discrete periods. Regulations 3 and 4. Regulation 3 covers these people up until the 30th of June. Regulation 4 covers them if their position isn't all sorted out by the 30th of June. So it's not regulating applications as such. What it's doing is saying, if you've made an application, these substantive provisions of the 2016 regulations continue to apply to you.
But that's made an application for...
Yes.
Quite. Not for a derivative residence card.
No, but if you happen to have made an application for a derivative residence card to prove your ongoing right
Yes.
to reside under Regulation 16, which these regulations give you,
which regulations
the
give
grace
you?
period SI.
Sorry,
allows-
why is it that the grace period regulations give you the right to apply for a derivative residence card?
Well, the scenario, it's not the grace period. Remember that an application for a derivative residence card will have been made under the 2016 regulations
understand
before
that.
they were revoked.
Exactly.
So that's where the ability to make it comes
Exactly.
from. In terms of the ability to deal with it, it's a mix of the grace period SI and the consequentials SI, because the consequentials SI gives the Secretary of State the ability to go on considering those applications after the end of the transition period, and where appropriate to grant them. And we say it's appropriate to grant if in fact under domestic law the person has a right of residence.
You're putting an awful lot of weight on where appropriate.
Well, I'm putting weight on where appropriate, but I'm also drawing together all the other strands. I
really-
realise I'm doing it in answer to questions, so it's perhaps
I
not.
mean, where appropriate, really, in your in your submissions, I understand, it just means where applicable.
It means that you can grant the application if there's
the conditions for granting
Yeah.
it are met.
met,
Yeah,
which
which
there are
is-
if there's a right of residence.
Yeah, which is where applicable. But can I just say, what you're saying is that the Regulation 3.6, which preserves Regulation 20 in respect of applications made before commencement day, in effect only applies if you are to those who are actually resident.
Sorry, is your lordship in Regulation 3.6 of the consequentials SI or the grace period SI?
The consequential, Schedule 3.
Yes. So that allows the Secretary of State to consider, it preserves the effect of Regulation 20. So
But
the Secretary of State
only in respect of those who are resident here.
Well, no, the Secretary of State can still consider the application, but it's going to be refused if the condition for a derivative residence card is that you meet the conditions. So if you're somebody who doesn't benefit from the right at all because you don't enjoy that right, it won't be granted. So if somebody's here, they benefit I'm going quickly. I see the time. I'm a Zambrano carer. I'm residing lawfully in the UK as a Zambrano carer on the 30th of December 2020. On the 1st of January 2021, I can assert, as against the UK, a positive right to continue residing in the UK because the grace period SI says I continue to enjoy that right. So I have a right to reside in law, and all I'm doing, I've asked on the 30th of December, Secretary of State, will you please give me a piece of paper recognising that right? And the Secretary of State says, when she decides the application on, say, the 15th of January, she says, yes, I'm happy to recognise that right because you enjoy that right by virtue of the grace period SI.
Why doesn't she put it into the grace period regulations? That's where it belongs.
It may be because there is a particular virus for those provisions, I don't know, but the fact is the legislation can work together. In my submission, it doesn't all need to be in one. That's why that provision is there for derivative residence cards, and similarly permanent residence cards and other things. There are circumstances in which all of those applications could be made and would succeed, but not on facts where there's no right.
But there are no situations in which the Regulation 11 can succeed, but you say, that's why it's meaningless.
It's OTOs. That's all we can say. We cannot. There may have been something in the drafter's mind. It may have been belt and braces. The important point we say, the countervailing factors, and I'll deal with those briefly after lunch, include the removal of the substantive right of residence, meaning that Regulation 11 it doesn't have any. It's air in effect, because there's no point in having a right of admission if there's no right brought into effect. Sorry, that doesn't make sense. There's no point to having a right of admission. It's meaningless because a right of admission is a right to be admitted to enjoy a right. So if the underlying right has gone, then there's no purpose.
Well, it means they'd be admitted, and goodness knows what can happen afterwards.
Remember,
for example, they might then have Article 8 rights or all sorts of other rights.
Yes,
or the Secretary of State might say, well, actually, A, I intended them to be able to stay, or B, I've screwed up here and it's my fault, I'll do the decent thing and I'll let them stay. We just don't know what will happen after they come in.
Yes,
They've been given the right.
two quick points to make. The first is recall that it isn't a right of admission as such in the grace period SI. It is a right, it's that the Secretary of State, Regulation 11 applies when an application is being considered. That's the first point. The second point to make is that if the Secretary of State could have given something to these appellants because for some reason they fell within the concession, she would have done. The point is they haven't got anything because there's nothing to give them, because the right
Well,
that they want.
admission.
Sorry?
Admission. It's not illegal. They aren't breaking the law by coming in.
Well, then we go back to the declaratory debate.
Thank you.
Anyway.
So we'll start again at 2 o'clock.
Yes.
But like